Hello everyone. Today we will gain some basic knowledge about contract laws through some basic multiple choice questions. So without wasting any time, let's start with it. First question is agreement, the meaning of which is uncertain, is which of the following? Options are A, void, B, valid, C, voidable, or D, illegal. The answer to this question is option A, that is agreement, the meaning of which is uncertain, is void. Next question is the acceptance of a proposal should be dash. The options are A, expressly given, B, impliedly given, C, given by consent, or D, all of the above. The correct answer to this question is option D, that is all of the above is correct, which means that the acceptance of a proposal can be given in express manner, in implied manner, or can be given by consent of another person. The next question is the codified law of the law of contract in India is which of the following? Options are A, the Indian Contract Act 1872, B, the Indian Contract Act 1973, C, the Indian Contract Act 1992, or D, the Indian Contract Act 1901. The correct answer to this question is option A. This means that the codified law for the law of contract in India is Indian Contract Act 1872. The next question is the consent given will be considered to be valid consent if there is options are A, coercion, B, undue influence, C, free consent, or D, misrepresentation. The correct answer to this question is option C, that is free consent. This means that the consent given will be considered to be valid consent only and only if the consent is given freely by meeting of minds. The next question is a void contract is a contract in which options are A, is not enforceable by law, B, where a contract does not have reasonable terms, C, when a contract declared void by the Indian Contract Act, or D, both A and C. The correct answer to this question is option D, that is both A and C. This means that a void contract is a contract which is not enforceable by law and which is declared to be void by the Indian Contract Act. The next question is how agency is created. Options are A, by direct appointment, B, by implication, C, by necessity, or D, all of the above. The correct answer to this question is option D, that means all of the above. This means that an agency is created by direct appointment, by the implication, and by necessity of the situation. The next question is the expression privity of contract means what? Options are A contract is a contract between parties only. B, a contract is a private document. C, only private documents can be contract. Or D, the contract may be expressed in some usual and reasonable manner. The correct answer to this question is option A. That means a privity of contract means a contract is a contract between the parties only and no third person or a third party can have any interest in the contract unless and until it is mentioned in it. The next question is if only a part of consideration or object is unlawful, the contract is dash. The options are A. The contract is valid to the extent the same are lawful. B. The contract becomes void to the extent the same are unlawful. C. The contract becomes valid as a whole. Or D. The contract is void as a whole. The correct answer to this question is option D. This means that where only a part of consideration or object is unlawful, the contract becomes void as a whole. The next question is agreement without consideration is valid when made in which of the following situations? Options are A. Out of love and affection due to near relationship. B. To pay a time-barred debt. C. To compensate a person who has already done something voluntarily. Or D. All of the above. The correct answer to this question is option D. This means that all of the above situation, that is, where an agreement is made out of love and affection due to near relationship, the agreement is made to pay a time-barred debt, or the agreement is made to compensate a person who has already done something voluntarily, is valid even without any consideration. The next question is, which of the following maxim is not related to the law of contract? The options are A. Consensus ad idem. B. Essentio mentum. C. Ex nihilo pacto not non auditor action. Or D. Actus non facit reum nisi mens sit rea. The correct answer to this question is option D. That means actus non facit reum nisi mens sit rea is a maxim which is not related to the law of contract. The question is, an acceptance on a telephone should be A. Heard by the offerer. B. Audible to the offerer. C. Understood by the offerer. D. Voluntary understood. Or E. All of the above. The correct answer to this question is option E. That is all of the above. Which means that it should be heard by the offerer. It should be audible to the offerer. It should be understood by the offerer. The acceptance should be voluntarily done by the offeree. This question is, the meaning of void-ab-initio is, options are A. A void contract. B. A contract void from beginning. C. A voidable contract. Or D. None of the above. The correct answer to this question is option B. That means void-ab-initio means a contract which is void from the very beginning of its inception. The next question is, the bailment of goods as security for payment of a debt or performance of a promise is called what? Options are A. Pledge. B. Bailment. C. Contingent contract. Or D. Agreement. The correct answer to this question is option A. That means the bailment of goods as security for payment of a debt or performance of a promise is called a pledge. The Section 180 of the Indian Contract Act 1872 provides for what? Options are A. A pledge where a pawner has only a limited interest. B. Suit by a bailior or bailee against wrongdoer. C. Appointment of relief or compensation obtained by such suit. Or D. Pawnee's right where pawner makes default. The correct answer to this question is option B. That means Section 180 of the Indian Contract Act 1872 provides for a suit by a bailior or a bailee against the wrongdoer.